See, in the previous part we have seen what is the relevance of the Citizen Charter Bill, what are the various provisions in the bill. In the subsequent part, that is in the second part of the discussion, let us consider the criticism of the Citizen Charter Bill and the recommendations made by the Parliamentary Standing Committee headed by Shantaram Naik. So the first criticism of the bill is, see, the Citizen Charter Bill, it is applicable both for central government, state government as well as the local government. So some people have expressed a concern saying that how can the Citizen Charter Bill which is being passed by Parliament can be applicable for a state government? Will it stand the judicial scrutiny? The Parliamentary Standing Committee said that, after it was referred to Parliamentary Standing Committee, in the Indian Constitution in the 7th schedule there were 3 lists: Union list, state list and concurrent list. In the concurrent list there is one entry 8, which deals with actionable wrongs. That is, the governments, the central government, the state government and the local government, which are having the responsibility to deliver the goods and services to the citizens, if they don't do it in time, they amount to actionable wrongs. So this was mentioned in the concurrent list, in the entry 8. So what does that mean? On any subject mentioned in the concurrent list, both the Union Parliament as well as the respective legislative assembly can legislate. So entry 8 in the concurrent list will empower the Union Parliament to pass the Citizen Charter Bill. So this is the clarity given by the Parliamentary Standing Committee. Again, as the concern which was expressed saying that how can the Citizen Charter Bill enacted by Union Parliament can have applicability for the state governments. This is applicable because this legislation is passed taking the power from the concurrent list. In the concurrent list there is one entry by name entry 8 which deals with actionable wrongs. So a subject which is mentioned in the concurrent list, on that particular subject the Union Parliament can legislate. So once this Citizen Charter Bill becomes an act, it is applicable for the central government, state government as well as the local governments. The second criticism is, under the Citizen Charter Bill, only a citizen is entitled to make a complaint. That is, non-citizens, that is the foreigners, they are not eligible. Take Gujarat and Rajasthan. The state of Gujarat and Rajasthan, they have also passed similar legislations like the Citizen Charter Bill, which are called Right to Service Act. So there in these states, even the foreigners, that is the non-citizens, they were given the opportunity to make a complaint, because under the Indian law, even a foreigner is eligible to apply for a driving license. Under the Indian law, even a foreigner is eligible to apply for a driving license. So once he applies for a driving license, once he gets a driving license, if he has got any grievance, he has to make a complaint. And the Gujarat state government and the Rajasthan state government, in their respective states, the legislations there, that is the Right to Services Act, they are allowing even the non-citizens, that is the foreigners, to make the complaint. If the state governments are doing, why not the central government? So the Parliamentary Standing Committee requested the central government, why not the citizens can make a complaint to redress their grievances? So this is one criticism. The criticism is, the non-citizens, that is foreigners, they are not allowed to make any complaint. Then the third criticism is, see, if you consider several legislations like National Food Security Act, the Competition Commission Act, the Consumer Protection Act, the Mahatma Gandhi National Rural Employment Guarantee Act, these legislations, they have got their own grievance redressal mechanism. So now where the citizen has to give a complaint, it is under the Citizen Charter Bill or under the mechanism which was created in the respective legislations. So I told you that when I discussed about the provisions, penalty will be levied to the extent of 50,000 rupees. Part of the penalty will be given as compensation to the citizen if he doesn't get the good or service in time. So this compensation to be paid by the citizen, where it should be taken from? From the independent grievance redressal mechanisms which were set up in the respective legislations, or under this Citizen Charter Bill. This is one confusion. And apart from that, the bill is silent on the qualifications of designated authority. Who should be the designated authority? What is his qualification? What is his eligibility? That was not defined in the bill. Similarly, the search committee, which will assist the State Public Grievance Redressal Commission or the Central Public Grievance Redressal Commission, who are the members, how they are appointed, what are their qualifications, what are their eligibility, they were not detailed, they were not defined in the bill. That is another criticism. Apart from that, the Citizen Charter Bill does not have a system of incentive and disincentive. The good behavior has to be rewarded and the deviant behavior has to be punished. The public officials who are providing the goods and services to the citizens within the stipulated term, they need to be encouraged. How do you do that? You have to provide them financial incentives. You have to provide them awards. So that mechanism is not there in the present bill. So to encourage the public officials and to create competition within themselves, we need to have a system of incentive and disincentive. The right people, those who are doing well, who are performing well, they should be given extra financial pay, financial incentive. They also need to be given reward so that their morale will increase, they will be motivated to perform much better. This is not there in the bill. This is another criticism. So like this, there were several criticisms on the provisions of the bill. Let us consider the recommendations of the Parliamentary Standing Committee. Recommendations of the Parliamentary Standing Committee. So the first recommendation is, what did I say? The non-citizens, they are not allowed to make a complaint. The Parliamentary Standing Committee recommended that please allow even the non-citizens to make a complaint to redress their grievances. And apart from that, please specify the qualifications. Who should be appointed as the designated authority and who should be appointed as the search committee. Who are the people to be appointed as the search committee. And then the Parliamentary Standing Committee also recommended let there be a system of incentive and disincentive to encourage the people, to reward the good behavior and to penalize the bad behavior. So to motivate the public officials to effectively deliver the goods and services to the citizens, we need to have a system of incentive and disincentive. Fine. This is another recommendation made by the Parliamentary Standing Committee. And when I discussed about the grievance redressal mechanism, the citizen can file a complaint to the grievance redressal officer. The grievance redressal officer has to redress the grievance of the citizen within 30 working days. But there may be some emergency services. For example, I met with an accident. If I have a certificate saying that I belong to BPL category, I will be operated free of cost in particular corporate hospital. So that particular certificate I need it in urgent. And if you keep this as 30 days, I will be at loss. So the Parliamentary Standing Committee said that don't make that 30 working days mandatory for every service. If there is any emergency service, cut down the time. Try to redress the grievance of the citizen within the shortest possible time. This is another recommendation made by the Parliamentary Standing Committee. So these are several recommendations made by the Parliamentary Standing Committee. And apart from that, when I gave the definition of the public authority, non-governmental organizations who are substantially funded by a government, that is the central government or the state government, they also come under the category of public authority. But what do you mean by substantially funded? Is it 50%? Is it 70%? Is it 90%? No clarity. The Parliamentary Standing Committee recommended that please define the word substantially financed. The term is vague. So this is another recommendation made by the Parliamentary Standing Committee to make the provisions in the Citizen Charter Bill much more effective.